Let me say this up front, because people always twist this the wrong way. I do not think it's unreasonable to take an Uber to the hospital. And this is not legal advice. But if you're asking me whether it can affect your personal injury case, the answer is absolutely yes. And most people have no idea how much it matters until it's too late. Here's the situation I see all the time. You get into an accident, a car crash, a slip and fall. Maybe something doesn't feel right. But you're not bleeding out, you're not unconscious, and you're trying to be practical. You don't want a massive ambulance bill. You don't want the drama. So you open your phone, call an Uber, and head to the ER. From a human perspective, that makes total sense. From an insurance company's perspective, you just handed them ammunition. Because the first thing they're going to say is this: if it was really an emergency, why didn't you take an ambulance? And once that seed is planted, everything else you do gets filtered through that assumption. Here's how the argument usually goes. You take an Uber to the hospital. You get checked out. Maybe the hospital says, you're okay or nothing is broken. Or follow up with your primary care doctor. Now the insurance company looks at your records and says, see, even the hospital agreed this wasn't medically necessary. And those two words matter more than almost anything else in an injury case: medically necessary and reasonable. Insurance companies only pay for treatment that meets those standards. Juries are instructed to award money only for treatment that meets those standards. So now they're saying your visit wasn't necessary, the bill isn't reasonable, and therefore they shouldn't have to pay it. But it doesn't stop there, because this also bleeds into how they value your pain and suffering. I've watched adjusters and defense attorneys make this exact argument to a jury. Ladies and gentlemen, this person was worried about the cost of an ambulance. They chose an Uber instead. Does that sound like someone who believed they were seriously injured? And once that idea lands, it changes everything. Now, let me give you a real example so you understand how this plays out in the real world. In July of 2019, in Cook County, Illinois, there was a motor vehicle accident case where the injured plaintiff declined an ambulance at the scene and later took a ride share to the emergency room. The defense hammered that decision during litigation. Their argument was simple: if the injuries were truly severe, emergency transport would have been necessary. The jury ultimately reduced the damages significantly, citing doubts about the severity and urgency of the injuries based on early medical decisions. That case didn't turn on whether the person was hurt. It turned on how their actions looked after the fact. And that's the part people don't understand. Your case is not judged in real time. It's judged months or years later by people who weren't there, reading documents, listening to lawyers, and trying to decide whether you're credible. Every decision you make after an accident becomes part of that story. Now, does this mean you should always take an ambulance? No, and anyone who tells you that is oversimplifying the issue. But you need to understand the trade-off. When you take an Uber, you're sending a signal fair or not that you didn't believe the situation required emergency care. That doesn't automatically kill your case, but it raises skepticism. And once skepticism enters the room, your claim is worth less money. I've also seen this affect settlement negotiations in a very real way. I've had cases where we were talking about a $50,000 settlement, and the insurance company said, look, this person was worried about a few $100s for an ambulance. Are we really supposed to believe their pain and suffering is worth tens of thousands? And suddenly that $50,000 becomes $25,000, not because the injuries magically changed, but because perception did. And here's the part that frustrates people the most. They weren't trying to game the system. They weren't lying. They were trying to be responsible. But the system doesn't reward responsibility. It rewards documentation and consistency. Insurance companies are trained to look for contradictions. Jurors are trained implicitly to look for behavior that makes sense. And when your actions don't line up perfectly with the injury you're claiming, you pay for it financially. So what's the takeaway here? The takeaway is not never take an Uber. The takeaway is understanding that every post-accident decision creates a narrative. If you choose an Uber, be aware that it may be questioned later. If you go to the ER and are discharged quickly, expect that to be used against you. If you delay treatment, that delay will be highlighted. None of this means your case is over. It means your case just became harder. And this is why, whenever people ask me questions like this, my answer is always the same. Think beyond the moment you're in. Think about how your choices will look to someone who doesn't know you, doesn't trust you, and has a financial incentive not to believe you, because that's exactly who will be evaluating your claim.